The House will come to order. Report from the Committee on Rules and Legislative Administration.
Pepin from the Committee on Rules and Legislative Administration, pursuant to Rules 1.21 and 3.33, designates the following bills to be placed on the calendar for the day for Thursday, April 27, 2017, and establishes a pre-filing requirement for amendments offered to the following bills. House File Numbers 859, 985, 1118, 1226, 1538, 1542, and 1702. Yep.
Recognize the member from Washington, Representative Juergens. For what purpose do you rise?
Point of personal privilege.
State your point of personal privilege.
Thank you, Mr. Speaker. Members, I rise today to acknowledge the generosity of a local business. Actually, two businesses owned and operated by the Bruber family. The companies are Simix and Persolvent, and with us today are Jay Bruber, Vince Arnoldi, Ashley Bruber, Lindsay Hickey, and Lori Bruber, as well as several team members in the balcony. Now, all of us recognize the brand of Simix and are familiar with their meatballs and their lasagna, and most of us have probably used the online payment processing or scheduling applications for schools and other customers, even if we aren't aware that those services were provided by Persolvent. The culture of Simix and Persolvent not only encourages team members to be generous, but gives them numerous opportunities to give back to the less fortunate. I'll read a resolution in a moment, but there are a couple things that I want to point out. First, Persolvent and Simix donate 10% of their gross profits to charity, and last year they added a new social impact division called Payments for Change that donates 50% of the gross profits to charity. Second, to promote a culture of generosity, Persolvent and Simix launched a new volunteer time off program this year that for volunteer time off program that allows all team members up to 1 week of paid time off to volunteer for a nonprofit of their choice. This is in addition to their paid time off. Members, we in the legislature have the opportunity to help people throughout the state. But think of the impact if we had more companies like Persolvent and Simix. Through their generosity, they're making a difference throughout the state, across the country, and around the world. At this time, I'd like to read the resolution. A House resolution honoring the Bruber family, whereas those who generously give back to their communities perform a vital public service and are deserving of special legislative recognition. And whereas two companies owned by the Bruber family of St. Paul Park, Persolvent, a payment processing company, and Simix, a frozen food company, have consistently demonstrated such generosity, donating 10% of their gross profits to charity and implementing a volunteer time off program to encourage team members to volunteer for the nonprofit of their choice, while allowing them to take up to one extra week of paid time off in order to participate in the program. And members, while I've been aware of this company and wanted to recognize them today, their office is physically located in Representative Frankie's section of or side of the district. So at this time, I'd like to yield to Representative Frankie.
He will yield. Representative Frankie.
Thank you, Mr. Speaker. Whereas in 2016, Persolvent added a new social impact division, Payments for Change, which donates 50% of all gross profits to charity. Persolvent, Simix, and Payments for Change partner with a number of organizations, including Feed My Starving Children, Second Harvest Heartland, and the YMCA, sharing and carrying hands, and many other in order to impact the world, both locally and globally. And whereas the companies also sponsor the community of Matomo, Kenya, through donations to their students, hospitals, and children with special needs. Now therefore, be it resolved by the Committee on Rules and Legislative Administration of the House of Representatives of the state of Minnesota that it thanks and commends the Bruber family for their many generous contributions to those in need in Minnesota and around the world. Dated April 3rd, 2017. Signed, Kurt Dowd, Speaker, Minnesota House of Representatives. Joyce Pepin, Chair, Rules and Legislative Administration. Tony Juergens, State Representative, and Keith Frankie, State Representative. Thank you, Mr. Speaker. And let's give a big round of applause to the Bruber family.
Calendar for the day. The first bill on the calendar for the day is House File 1702. The clerk will report the bill.
House File number 1702, number 7 on the calendar for the day, an act relating to juvenile justice, the first engrossment.
Recognize the member from Morrison, Representative Kresha, to introduce your bill.
Thank you, Mr. Speaker. And that is my bill, but I believe we have a couple of amendments to report.
Representative Kresha offers the following amendment. The clerk will report the amendment.
Kresha moves to amend House File number 1702, the first engrossment, and the amendment is coded A5.
Recognize the member from Morrison, Representative Kresha, to introduce your amendment.
Thank you, Mr. Speaker and members. This amendment just simply gets us in similar language with the Senate so that when we pass it out of both houses, we'll be able to concur and move right to the governor's desk. I would appreciate a green vote.
Any discussion on the A5 Kresha amendment? Seeing no discussion, all those in favor of adoption of the A5 amendment signify by saying aye. Those opposed, no. The motion prevails and the amendment is adopted. Representative Kresha offers the following amendment. The clerk will report the amendment.
Kresha moves to amend House File number 1702, the first engrossment as amended, and the amendment is coded A4.
Recognize the member from Morrison, Representative Kresha, to introduce your amendment.
Thank you, Mr. Speaker and members. And this is by far the most important amendment because this changes the title of the bill to the champion of this, and that is allows us to cite this in law as McKenna's law. And as I present the bill, I think you'll agree and you'll know why. So I would ask for a green vote on this amendment as well.
Any discussion on the Kresha A4 amendment? Seeing no discussion, all those in favor of adoption of the A4 amendment signify by saying aye. Those opposed, no. Motion prevails and the amendment is adopted. There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File number 1702, as amended.
Third reading. Recognize the member from Morrison, Representative Kresha, to introduce your bill as amended.
Thank you, Mr. Speaker and members. So I've been trying to find the right words for this bill, and I'm very happy to have McKenna and her siblings and her family up in the gallery with us today. And I kept going back and forth of how I was going to present this bill. And what I ultimately came back to was the story that McKenna has told in committee from time and time again. When I first met McKenna and her grandma Kathy, she came through the Child Protection Task Force, came in the public part of the meeting and told her story. And what has inspired me in this whole process is the fact that for all the things that we do down here, members, to keep in mind that there are times when we listen, when we stop and listen to the people that we represent, we can champion their efforts and pull them forward. So with that, members, I would like to share McKenna's story with you because she can't because of customary usage, but I'm going to share the same story that I've heard time and time again. My name is McKenna Ehrenholtz, and I'm 12 years old. I'm writing to request a hearing on House File 1702, telling foster kids they have a right to an attorney. We need your help. This law is important to me, my brothers, sisters, and all current and future foster care kids in Minnesota, because had I known I could have had someone to give me a voice, I may not have been sent back so many times to neglect and abuse. See, us kids have an opinion. It is our lives that are being neglected and abused. At least that's how it was for us. I am one of 5 kids in my family and the second oldest. I have been in the system for as long as I can remember. My grandmother told me there were 17 cases on us since 2006. My parents were mentally sick and drug addicts. My mom was unable to take care of us and left us 6 years ago. The court ordered her not to see us until we are 18, and that is very hard for us. My dad tried to take care of us, but failed horribly. When he took care of us, we were starved, and he physically and mentally abused us. He gave us nasty clothes. I even had to scrape dog doo-doo off our clothing so that we would have something to wear for school. I would find whatever I could find to feed my sister and brother. A restaurant down the street knew our situation and helped us eat at least one time a week. And we would sneak canned goods from my dad and then bring them up to our rooms and open them with butcher knives. Social workers and our guardian ad litem never listened to us. We were always sent back to live with him. I was never informed before I met my grandparents that I was allowed an attorney, or that someone could have been there to listen to me. One thing that is important for people like yourselves to know is that I and my brother and sisters were too afraid of him to speak up in front of him. We knew if we did, he would hurt us. Never, ever let a child be interviewed in front of their parents. See, in 2014, on my brother's 11th birthday, we met our grandfather and his fiancée for the first time. Meeting Grandpa and Grandma Kathy was good because in September we were once again taken out of our home and put into foster care. My grandpa and Grandma Kathy went to court to help us. They became our foster care parents after 6 months of being with other foster parents. They fought hard for us so that we could have a good future. During our stay with our grandparents, we had to visit Dad at his house when we didn't want to, even for a week at a time, and it was horrible. I remember he even yelled at us about missing a brush that he had lost and blamed us for it. He punched and hit me and my siblings many times. We were fed maggot cookies. We were yelled at, ate on the floor with a box for a table with our dog's doo-doo on the floor. My social worker would come and tell him to feed us because he wouldn't do so unless they told him to. We had to see my dad naked. We survived this too because we were used to it. They still wanted to send us home even after the maggot cookies and yelling in gross, dirty house. I kept wondering, why would they send us back? My grandmother and grandpa asked our guardian ad litem, social worker and county attorney, for an attorney for us, but they didn't listen. I asked for one after I was explained by my grandparents what one was and what they would do for me, and was not granted. What really saved us was that my brother and sisters and I wrote letters to the judge telling him all that we had been through. We were finally appointed an attorney. Things changed. They finally listened. I have been punched, starved, and neglected, and I don't want anyone else to go through that. So I think the law needs to change. The people that make the laws, like yourselves, need to hear us kids who are the ones who are going through this stuff. So please talk to the kids like me and ask them what they need. I wish I could have had parents that were normal, but they weren't. And so for us, the best thing in the whole world was to have a new home to go to, which our attorney helped us get. My grandma and grandpa saved our lives. But what about all the other kids that have no one to help them and listen to them? Who should tell them they are allowed an attorney? Kids don't know this and may be too scared to ask. If kids are allowed an attorney, someone should tell them about that. One more thing. The court is making us have visits still with my dad, but I refuse to go. I have nothing to say to him. So to sum things up, please pass this law to help all kids have a voice. We are young, but we are also smarter than you think. Save our kids' future, inform them that they have a voice, give them the tools to help. Give them an attorney. You give them to parents, or at least my dad had one. So please, I really want this new law to pass so that other kids in Minnesota don't have to go through what my brother, sisters, and I went through. Thank you for your time and listening. Your friend, McKenna. I had one more piece that her grandmother passed on to me as well, and she said, "We're so thrilled to be at this point. McKenna wanted to make a difference for others. Although the law doesn't benefit her and the siblings, it makes them happy. All of these kids have the biggest heart." Members, what this bill simply does is fulfills something adults should be doing, and that is telling these kids when they get into this situation, they have the right to counsel, they have the right to have an objective voice when they don't have one. And so, what I'll leave it with, I have a couple of points, Mr. Speaker, members, and I'll stand for questions. But we hear a lot about courage down here, and I will tell you, this young lady has now redefined courage for me. And so with that, members, I'll stand for questions.
Discussion on House File 1702. The member from Ramsey, Representative Pinto.
Thank you, Mr. Speaker, and I want to thank Representative Kresha for advancing this bill, and especially thank McKenna and her family for their courage and for her courage and their persistence in pursuing this. This is a really needed change. I do want to note for members that this will make sure that kids have notice of their right to an attorney, which they should have. And again, I'm so grateful for moving that forward. It's important that we provide funding and support for the system that will provide attorneys for kids as well. Speaking with the, I know that our public defender system, for example, is at 70% of the resources that they should be at considering their caseload. That's just for the attorneys. For the rest of the system, the support staff, barely half of what they should be. It's important that as we're providing notice of the right to kids of attorneys, that we're also actually providing the attorneys to provide that support as well. And I trust that our members of the conference committee coming out of the House will continue to advance that. I know that we all share the goal of making sure that kids have representation, and I'm so grateful to Representative Kresha and especially to McKenna and her family for making sure that kids are aware of that representation. Thank you, Mr. Speaker.
The member from Dakota, Representative Halverson.
Thank you, Mr. Speaker. I want to thank the author of the bill for listening. This is a wonderful example that McKenna has set for the rest of the state, that your voice matters to us, whether or not you feel like you have power in the system. Your voice matters to us. And so I hope that McKenna's example will be heard far and wide through the state of Minnesota, for the children of Minnesota, for the people who feel like they're being left out, left behind, like they don't have a voice. Your voice is heard, and we are here to amplify your voice, to hear your calls for justice, and to do the work that you deserve. And so, McKenna, I want you to know that you are making a difference not just for the kids in the juvenile justice system, but for people around the state and around the country who feel like they don't have a voice today. You've shown them that you have power just by being you and just by speaking up. So thank you, McKenna. Thank you, Representative Kresha.
The member from Ramsey, Representative Lesh.
Thank you, Mr. Speaker and members. I'd add my voice to the chorus of individuals complimenting McKenna on her poise and message. I will tell you, McKenna, that you impressed a lot of legislators here, far more so than the average testifier on an important bill. There are a lot of testifiers and bills that come through here, and it might be once every few sessions that someone comes through who does as good a job as you did and represents as well as you did. So thank you for that. I do have a question for the author, Representative Kresha, if he would yield, Mr. Speaker.
He will yield. Representative Lesh.
Thank you, Mr. Speaker. Representative Kresha, echoing the questions raised by Representative Pinto, can you tell me how you got the public defenders to take on more cases with no fiscal note?
Representative Kresha.
I'm really good, Representative Lesh.
Representative Lesh.
Mr. Speaker, thank you, Representative Kresha. I want to point out one thing. When I was in law school, I had a law professor, Professor Larry Bakken. If you're listening, Professor, shout out. He used to be the mayor of Golden Valley, actually, and he was a professor at Hamlin Law School. And when we take a class from him, he used to say, you know, there are two bills that go through every legislature. The bill that makes the world right for humanity and the appropriations bill. We all want to vote for that first one, but when it gets to voting for that second one, we start to get a little squeamish. So it may be, Representative Kresha, that they can absorb this, but I just know, echoing Representative Pinto, that we have not been that good to the public defenders for many, many years. So I hope we can keep that in mind. Thank you.
The member from Morrison, Representative Kresha.
And thank you for that. And thank you, Representative Lesh, for calling that out. As I pointed out in public safety, I do believe we need to make sure the resources are there. What this bill does, and the reason we're here, is because it's already in law that these kids are entitled to counsel. We just aren't telling them. So what this does is ensures that social workers will let them know that they have that already existing right. I fully expect, and I'm happy to do so, that I will come back with fiscal notes at the appropriate time and try to get that funding. We've been trying to do it this year. We haven't been as successful as I'd like. But this should be a catalyst for all of us to put 134 votes behind this cause. So thank you, Representative Lesh, and you called out appropriately, and I agree.
The member from Anoka, Representative Scott.
Thank you, Mr. Speaker, and thank you, Representative Kresha, for bringing this bill, and thanks to McKenna and her family and her grandma Kathy and her husband, her grandpa. And one of the things that struck me as a result of this bill and of McKenna's testimony was that I was always under the impression that the guardian ad litem was there to represent the best interest of the child. And in her testimony, she shared that that wasn't the case for her and her siblings. And so I want to challenge this body to take a serious look at that program in the future. I know of at least 2 other cases right now where this seems to be happening in a very similar way. And it's very frustrating as a legislator because we're not supposed to intervene with the courts and those sorts of things. But I just want to challenge this body to take more of McKenna's words at heart when she talked about the guardian ad litem, and these kids were pleading to the guardian ad litem and nothing was being done on their behalf. So that's just my word. Please vote green. This is a great bill. Thanks.
The member from Blue Earth, Representative Considine.
Thank you, Mr. Speaker. And yes, McKenna is one of the most remarkable young women that I think I have ever met. And how about a round of applause for McKenna and all the work that she did?
The member from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker. And members, Representative Kresha has really done a great job with this proposal, and McKenna did a great job in making the points. Members, children are currently entitled to a public defender. if they're over the age of 10. However, the Children's Law Center has really been stepping up to represent these children that have not had a voice. In addition to the children in the process before termination of parental rights being entitled to a lawyer, which people weren't telling them, and sometimes adults were waiving that lawyer without their knowledge or consent, there are children that are in the foster system that have already had their parental rights, their parents have already had their parental rights terminated, who are no longer entitled to a lawyer. So once that court process has ended, these children are no longer entitled to a lawyer. The Children's Law Center has really stepped up in an attempt to make certain that children's voices are being heard. We need to make certain that we have the resources. If we are insisting that these children be removed from the home, as we are, if we are terminating parental rights, which we are, we need to make sure that the children's voice about what they want is heard. So the guardian ad litem's job is to make a recommendation to the court about what their interpretation of the best interest of the child is. But a lawyer is to advocate for what the child wants. And we all know that if you, as a child, are told that you're supposed to do something that's in your best interest, but it isn't what you want, you may not get the same result as a court as if it is consistent with what the child wants. It's really important that these children have a lawyer. It's really important for folks like McKenna to step up and tell their story so that we hear it, because many times these children are forgotten. So thank you, Representative Kresha. I look forward to working with you to continue to move in the direction of making sure all of these children have a lawyer.
Any further discussion? The member from Morrison, Representative Kresha.
Well, thank you, Mr. Speaker, and thank you, members. Thank you for all the comments. And yes, of course, and after this bill passes, McKenna and her siblings will be down joining us, and I hope that you all get a chance to meet them. She certainly has restored my optimism in humanity, and I think is a lesson for all of us that every time we think things are a little bit hard down here, it's not quite that hard, that we can actually move good legislation, we can do things, and there are people that are going through struggles that we can never know. The last comment I'll make is that, remember, members, not every kid is going to be getting this service. This is for the children that the court has decided they're about to go through the judicial proceedings to be, the parental rights have been terminated and they're out of home placement. Giving them representation to go through a very complicated court system, and more importantly, giving them objective third-party counsel so that they can make decisions. And as McKenna so eloquently said, we're smarter than you think we are. And I think about a kid that has gone this far has probably seen more things than many of the adults, and telling them of their counsel is not that tough. So McKenna, we're about to vote on this, and I want you to watch that board.
Seeing no further discussion, the clerk will take the roll on the bill. The clerk will close the roll. Davney votes aye. Sundin votes aye. There being 130 ayes and 0 nays, the bill is passed as amended and its title agreed to. The next bill on the calendar for the day is House File 1538. The clerk will report the bill.
House File Number 1538, number 5 on the calendar for the day, an act relating to real property, the first engrossment.
Recognize the member from Hennepin, Representative Smith.
Thank you, Mr. Speaker, members. I'm very proud of this bill. I would like to thank everyone who's been involved in this year-and-a-half odyssey of work. I'm very proud of the list of supporters, including Representative Ray Dean, Representative Nelson as co-authors. I also would like to thank the cities of support that have provided resolutions that are being handed out right now, including but not limited to the City of Bloomington, Chanhassen, Edina, Golden Valley, Hopkins, Maple Plain, Newport, St. Anthony Village, St. Louis Park, Wayzata, and Woodbury. Additionally, members, the Minnesota Housing Options Coalition are supporting this bill, American Institute of Architects, the Association of General Contractors, the Association of Metropolitan Municipalities, the Builders Association of Minnesota, the Builders Association of the Twin Cities, Minneapolis Downtown Council, the Minnesota Association of Realtors, and the Minnesota State Building and Construction Trades Council. A full range of housing options are critical for the well-being of Minnesota. Since the end of the recession, construction of homes has increased dramatically, yet not the same for condos and townhomes. In 2007, 23% of the market were townhomes. In 2015, only 3%. Similarly, since 2007 to 2015, homes rose 80%, townhomes decreased 70%. This legislation seeks to encourage condo and townhome development by reducing the risk of litigation associated with these types of construction projects. It encourages all the parties to resolve their differences that are defect disputes through negotiations and mediations without impacting owners' warranty rights. I ask for your support.
Representative Hillstrom offers the following amendment. The clerk will report the amendment.
Hillstrom moves to amend House File Number 1538, the first engrossment, and the amendment is coded A2.
Recognize the member from Hennepin, Representative Hillstrom, to introduce your amendment.
Thank you, Mr. Speaker and members. Members, one of the troubling parts about this proposal is it requires a majority of the property owners to vote in favor of the beginning of a suit. Now, members, just as with stockholders or stakeholders in other areas, we usually require that there be some notice, and we require that they be told when a lawsuit is going to be voted upon. But we usually give the board the authority to actually take the vote on whether or not to file a lawsuit. So what's in this statute proposal currently really is a larger burden than we place on many other entities. And so all I am asking for in this amendment is to say you must notify all the property owners. You must tell them the date that you're going to vote, the board's going to vote on whether or not to file a lawsuit. You must tell them at least 30 days in advance. But once that is done, it really is the board who would make the determination on whether or not the lawsuit should be filed. So members, that's the amendment, and I ask for your support.
Recognize the member from Hennepin, Representative Smith.
Thank you, Mr. Speaker, members. I oppose this amendment. Parts of this are very good and I support, but in a whole, I ask for a no vote. The entire bill, one of the main components is whether the board of directors is voting or whether the members of the association are voting. It is true the rules for this bill for these associations is different than a corporation such as 3M. But there's unique things happening in this industry that the list of supporters that I read previously recognize. Many of you have personal stories about this situation. This is different. I ask for your no vote.
Any further discussion on the A2 amendment? Seeing no further discussion, seeing no further discussion, all those in favor of adoption of the A2 amendment signify by saying aye. Aye. Those opposed, no. No. The motion does not prevail and the amendment is not adopted. Representative Dean R. offers the following amendment. The clerk will report the amendment.
Dean R. moves to amend House File Number 1538. The first engrossment as follows, and the amendment is coded A17-0380.
Recognize the member from Hennepin, Representative Dean R.
Thank you, Mr. Speaker and members. I believe there's an amendment to the amendment as well.
Representative Dean offers the following amendment to his amendment. The clerk will report the amendment.
Dean R. moves to amend his amendment to House File Number 1538, the first engrossment, as follows, and the amendment to the amendment is coded RA17-009.
Members, as a point of clarification, Representative Dean offered, pre-filed an amendment that was coded A17-0388, which contained a technical error. He has since brought amendment coded RA17-009. Pursuant to House Rule 3.33, paragraph E, the presiding officer has made a decision to allow that correction. So we are on that amendment that has the technical correction. And to introduce that amendment, the member from Hennepin, Representative Dean R.
Thank you, Mr. Speaker, and thank you for accepting the technical change. It was a critical change in the amendment to the amendment. And what this does is it changes the implementation date for projects that were constructed after July 1st, 2014. And why that date was arrived at is there are a lot of properties out there that currently the purchasers of those properties had bought them under certain contractual obligations in purchasing their projects, in their condos, in their buildings. And what the underlying original bill does is it actually goes backwards completely to sort of remove their contractual obligations through pursuing damages of claims as part of the association. And by changing the state, what I've done is I've tried to sort of meet in the middle. My original amendment had it being totally prospective, moving forward, so that those individuals that had purchased units are knowing, those that have already purchased those units would not be change of their actual purchase agreement that they had with the developer and the original building owner. By changing it to July 1st, we sort of come in the middle and realize that early on after we began construction, there were some projects that moved forward, and most of those projects, the defects have already been found out. They're already out there. So what this does is it goes back a few years and allows the opportunity for some defects that may not have been discovered yet to be considered under the new bill. And I appreciate this bill because we do have a existing difficulty in what's called the condo market. And that's having an adverse effect on the housing market as well. At the same time, I don't want to strip any of those owners of their rights that previously allowed them to make claims against building defects and problems. So I offered this amendment to the amendment, and I would hope that the body would support that in favor. Thank you.
Discussion on the motion to adopt the amendment to the amendment coded RA 17-009. The member from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Members, I appreciate the author's amendment and amendment to the amendment and his work on this bill. This has been a collaborative effort, and there's been a series of compromises with the myriad of people involved in this. I'm going to ask for a no vote on this amendment. I feel that in order to properly get this market back to where it was, we need to go back for the entire 10-year statute of limitations. No one's right in court is being eliminated. No one's rights are being taken away. Insurance companies, architects, they need the assurance that we're going to be able to move forward in this market in a way that's going to give them the type of protections they need to get this market back. I ask for a no vote. Thank you.
Any further discussion on the amendment to the amendment? Seeing no further discussion, all those in favor of adoption of the amendment coded RA 17-009 signify by saying aye. Aye. Those opposed, no. No. The motion does not prevail and the amendment to the amendment is not adopted. We're now on the underlying A17 amendment. Representative Dean.
Thank you, Mr. Speaker and members. So without this date back to July 1st, I'm assuming that A17 will not be able to be added to this. But I just want to caution members that freeing up the market is a good thing to do, but how we do that is also important. I mean, very important, because we're about to take away the contractual rights of many individuals that had purchased units under a provision of law during the time that they purchased their condo units. So in voting against this amendment and then voting for that bill, we're voting to take away the rights of people that purchase properties, some of them at a time when the market was not quite back yet, and some of those at a time when the market was back yet. And we will be in essence nullifying the way in which they purchased their unit through these changes. So I would ask that members vote in favor of this amendment. Thank you.
Any further discussion on the A17 amendment? The member from Hennepin, Representative Smith.
Thank you, Mr. Speaker, members. I ask for a no vote. Thank you.
Seeing no further discussion, all those in favor of adoption of the A17 amendment signify by saying aye. Aye. Those opposed, no. No. The motion does not prevail and the amendment is not adopted.
No more amendments.
There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 1538.
Third reading. Discussion on House File 1538. The member from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Would Representative Smith yield to a few questions?
He will yield, Representative Lesh.
Thank you, Mr. Speaker. Representative Smith, there are concerns that have been stated, multiple concerns about the bill as written, and I've heard from various folks that they think that despite those concerns, this bill is kind of being sold as a panacea for the lack of condo builds that we're seeing. And the folks that I've talked to about this seem genuinely sincere in their belief that this bill will solve that problem. And I can tell you, members, this is my 15th legislative session now, and there are a lot of bills that come through here that are sold as panaceas, as cure-alls for how it's really going to solve a problem. And I think there might be only one I remember that did that. Who remembers the putting Sudafed behind the counter to stop meth labs? And remember that? Yeah, okay. I was cynical about that, and sure enough, like, meth houses in the years after that pretty much disappeared, which floored me. I mean, I thought it would work. I didn't think it would work that well, but from looking at the perspective of a prosecutor and law enforcement, I was very impressed with the results for that. Now, since then, of course, markets have changed. It's being produced in other places and still sent here, so, but it still drastically reduced the number of meth houses we had, of farmers getting stuff stolen out of their fields. But I have some concerns about that. So my first question I have, Representative Smith, is regarding the requirement that you have to get homeowners who have contracted for this to have to get their agreement to take legal action to protect their rights. Would you support a similar provision for corporations in Minnesota to require corporations to get the same amount of consent from their shareholders prior to taking legal action to protect their rights or interests?
The member from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, we had a long discussion about this bill in Civil Law Committee, and I understand your position. I would ask you to get out your calendar and mark today's date down, because this may be the second time in your long and distinguished legislative career that this bill will solve problems in the marketplace. In regard to your hypothetical question, I would need to see the language, but my answer, Representative, is that this is a unique problem, a unique industry, and we need to act. We deal with problems in different industries throughout our beloved state every time we meet as a body. This is one of those times that I believe we need to come together and solve this problem. This list of supporters, I will save you all reading all their names again. It is long. This has been a very long discussion of this bill, getting this in the shape that it's in. For those of you that have a particular interest in this bill, you may know that the version in the Senate is different, and this bill is going to go to conference committee. The discussions for compromise, modifications will continue. So, Representative, please get out your calendar. This may be the second one. Thank you.
The member from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Hey, listen, Representative Smith, I'm open to be proven wrong, okay? It happened before, but I just think that I've been here 15 years, and like I said, a lot of it's sold that way. So I'll mark my calendar, Representative Smith, and maybe this is the second time in 15 years that I'm proven wrong on that. However, remember that this is a pretty drastic maneuver that we're taking at to suggest that it's going to solve a condo bill problem. We're interfering with people's right to contract. We're interfering, we're legislatively abrogating their due process rights. Those are two pretty big constitutional rights, and I'm sure some of the Tea Partiers over there would care about quite a bit, especially the right to contract. But you had brought up, if Representative Smith would yield to another question, Mr. Speaker.
He will yield. Representative Lesh.
Thank you, Mr. Speaker. Representative Smith, you had brought up that list of the folks or the municipalities supported. I think I saw Chanhassen, Edina, Bloomington, might be a couple others. Did you receive a letter of support from any local unit of government outside the metro in support of this bill?
Representative Smith.
Thank you, Mr. Speaker. Representative, there is not any documented support from outside the metropolitan area, but I know that there is support. And I know that your city of St. Paul really is interested in this bill. There's a development down at the old Ford plant that people are very encouraged that this bill becomes law to help out your beloved city. Thank you.
Mr. Speaker.
Representative Lesh.
Well, that's good. Thank you, Mr. Speaker. Representative Smith, that's good to know because they haven't talked to me about it. No one from St. Paul has talked to me about it. Now, here's what I tell you. I heard Minneapolis came and testified for it. Representative Anderson's not here, so she probably won't say anything about my wife now, who works for Minneapolis. But I know Minneapolis testified in favor of it. And I understand the reasons behind why some of these folks wanting it. It's just curious that your caucus has stated you're going to take care of greater Minnesota. And I hadn't seen a whimper from greater Minnesota about how this is going to help folks out there. But if Representative Smith would yield to a final question, Mr. Speaker.
He will yield. Representative Lesh.
Thank you, Mr. Speaker. Representative Smith, can you tell me how is the housing market doing overall in Minnesota right now? How are homes being built, or are we stagnating?
The member from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, the housing market is in a period of recovery since the Great Recession, and things are improving. But what's more important to your question is that we need to help out the condo and townhome development. These townhomes and condos for the low income and middle income, they are hurting. we need revisions in this area of the law to help them. That market is suffering greatly.
Representative Lesh.
Thank you, Mr. Speaker. Well, I'll tell you how it's doing, Representative Smith. It's booming. It's a booming. And yeah, maybe not for condos, but the suggestion by promoters of the bill that that's because insurance companies and developers don't want to build something where they're exposed to liability in this way. I don't know. Maybe it's a market thing. Now, I'm a guy who supports housing density. There are bills that I voted with your side of the caucus on this year and in years past, and Representative Nash knows this, to encourage housing density. Okay, townhomes and condos are going to get you to density where single-family homes are not. So I completely support the principles of having those condos and townhomes built where now single-family are getting built. But I'm just hard-pressed to believe that this is the way we go about it. And I can tell you, this is a banner year for insurance companies at the Minnesota Capitol. A banner year. You defer in favor of what insurance companies are saying. You swallow what they're telling you, hook, line, and sinker, instead of supporting your constituents' contract rights and due process rights. I could be proven wrong, Representative Smith, and I'm going to mark the date on my calendar. Okay, I'm going to talk to you in 2 years too. And maybe you're right, and quite frankly, I hope you're right. I just don't think that this is the bill. This is the way to go about doing it. So I'm going to be voting no.
The member from Hennepin, Representative Dean R.
Thank you, Mr. Speaker. And to reply to one of Representative Smith's comments, my amendment would have made St. Paul just fine in the Ford plant site. They would have been just fine moving forward. All the units that are going to be built there, they would have been just fine with that amendment. But you chose to vote it down. So again, this is going back and really giving individuals the opportunity to change the playing field that they built their properties on. And I'm a big supporter of the architecture profession. I'm a big supporter of general contractors. I'm a big supporter of all those folks. And yet, I look at this bill and there seems to be a lot of dissension yet. We all can roll out, long lists of people that are supportive. And I think that that's important to do that, but at the same time, it's not just a one-sided issue. There's two sides to this issue. And if Representative Smith would yield to a question.
He will yield. Representative Dean.
Representative Smith, can you explain to the body exactly why making this retroactive for a 10-year period is going to somehow free up the market that currently is doing okay in housing? It's actually doing really, really well in apartments, but how it's going to impact the condo market?
The member from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, part of the genesis of this bill were frivolous lawsuits that have been going on. In the last year of the 10-year statute of limitations, frivolous lawsuits are being brought forward. This bill will prohibit the frivolous lawsuits from going forward. The people involved in the construction, the architects, those people, including people in the Trades Council, this bill will give them reassurance that moving forward, these frivolous lawsuits will stop going forward as well as going back. I want to point out a letter of support that some of you may not have seen. It's from Harry Melander from the Minnesota State Building and Construction Trades Council, dated April 26, 2017. This bill will be beneficial to all of Minnesota. This is a great bill. Thank you.
The member from Hennepin, Representative Dean.
So I don't think you really told us how it's going to affect the market. I mean, I would venture to guess that we will see a lot more developers moving into the condominium market. And I think it will be really, really good for them moving forward. What this bill is actually going to do, it's going to free up capital, because it'll allow more capital to come in. It will also make insurance rates maybe better, maybe not. We always get promises from insurance companies that the things we do here will impact our insurance rates, and they seem to never really do that. But it will definitely relieve them of any liability that they currently are carrying for the past 10 years. And again, I'm really disappointed that you weren't willing to support the amendments that I brought forward, because I thought that that was trying to find that area of middle ground. And I think that for this bill coming back from conference committee, it's going to change, or it's not going to come back. And we've seen that happen with other bills that Representative Smith, has actually carried to conference committees in the past. And if this bill does not come back, we're going to be left in the same place we are today. And that's not going to help anybody. All the people that have signed on to support this, they're all going to be in the same place they were today. Not in a place that they could be by working together with both sides to get to that point where some people might be a little bit unhappy, but it's going to be people on both sides that are going to be a little bit unhappy. And I actually believe that the amendment and the amendment to the amendment would have had the same effect of freeing up financial capital, putting insurance companies somewhat at rest, although not completely at rest, with what has been going on the past few years. And I think that these lists that you handed out of, I guess it's about 11 cities, might be sitting in the same situation they are today. So I would encourage you, when you go to conference committee, to not be dogmatic of this bill and where it's at today, because my guess is given what has passed in the Senate, if you are dogmatic, this bill won't be coming back. Thank you, Mr. Speaker. I ask folks to vote no.
Representative Hillstrom.
Thank you, Mr. Speaker. If Representative Smith would yield to a question.
He will yield. The lady from Hennepin.
Thank you, Mr. Speaker. Representative Smith, could you clarify for me, if I purchase a unit in one of these common interest properties, and there is a defect in my unit, and only in my unit, so a building defect in my unit, in order for me to file a lawsuit for the building defect in my unit, would I have to get 50% of the people that own other units to agree to allow me to sue on that building defect?
The gentleman from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, no.
The lady from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker. And Representative Smith, could you please clarify why it is based on the language of your bill? Because it's my understanding that the association would have to sue on my behalf, and that they would have to get a majority vote of the ownership.
Is the lady from Hennepin asking the gentleman from Hennepin to yield? He will yield. The gentleman from Hennepin.
Thank you, Mr. Speaker. Representative, if the association is bringing the lawsuit forward, then the rules with the 51% and the other outlines need to transpire. If you're bringing the suit forward from you, the person, as you originally asked your question, then only you yourself would need to be in agreement with that.
The lady from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker. And if Representative Smith would yield to another question.
He will yield. The lady from Hennepin.
Representative Smith, could you tell me then, if 10 people had problems with their units, but no one else did, could those 10 get together and file like a class action lawsuit to deal with the defects of the construction, or would that be precluded by these provisions in this bill?
The gentleman from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, if they're listed individually, whether one at a time or as a group, as long as they're not a part of the association, then they can bring that suit forward without the 51%.
The lady from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker. So if Representative Smith would yield to another question.
He will yield. The lady from Hennepin.
Thank you, Mr. Speaker. So Representative Smith, say every single person that owned a unit wanted to sue because there was a defect with the construction of it. Would this preclude them from getting all together and deciding to sue not as the association, not as the board of directors, but individually they could all sue the contractor, even if it's every single unit, and they would not have to go through the board of directors at all?
The gentleman from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, if they were listed individually and they were for issues impacting their individual unit, then they could do that. If it's for common areas, then the association would need to be involved.
The lady from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker. So that's what I was getting to now. Representative Smith, if you would continue to yield.
He will yield. The lady from Hennepin.
Thank you, Mr. Speaker. So Representative Smith, based on what you said, what you just commented on the floor, if, for example, the roof of the common area leaks or is defective, and then it damages my unit, the association would have to file that suit, and that could only happen if 50% of the owners of the units voted to do that. Is that correct?
The gentleman from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, it depends on how the claim was written, perhaps.
The lady from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker. So members, I'd like to build things. I usually vote in favor of housing. I support housing. But I also believe that people should have the right to file a claim when they rightfully have one. And one of the things that happens in some of these proposals is that for the good of others, some people lose their rights and their protections. And members, this body has taken a pretty strong stance for property rights. And what this bill says now is that you, as an owner of one of these units, if you're harmed by the other, the common area, your property is damaged, you have to get 50% of the people that own that building, that own ownership in that, to decide to let you do the right thing. So members, that's really where this starts to get to be a problem. When you place the burden so strongly on getting even 50% of your neighbors to come to the meeting to hear that you have a problem, first you have to get them there, and then they have to all vote to agree to a suit, or 50% of them have to agree to a suit, you end up limiting someone else's property rights. So Representative Smith, I have just one last question for you, and then I'll sit down. But Representative Smith, these common ownership interests are allowed to place things in their contracts when they sue the property. They're allowed to decide who's going to be responsible for snow plowing, or who's going to be responsible for general maintenance, and purchasers contract for that when they buy it. Would this provision prohibit the buyer and seller from placing language in the bill that would say you don't have to have 50% to file a lawsuit on behalf of the interests in your property, or would that be precluded by this statute at purchase?
The gentleman will yield. The gentleman from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, could you restate your question, please?
The lady from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker. The question is, Representative Smith, we allow people who are going to buy and sell property to contract for who's going to be responsible for different provisions. And when you buy the property, you get to read the contract about what you're allowed to do and what you're responsible for. Would the language in this bill keep the seller of the property from placing a provision in the bill which would not require the 50% vote to file a lawsuit on these kinds of claims?
The gentleman from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Representative, it depends somewhat on exactly the language that you're speaking to. These hypotheticals are good for the discussion to understand the bill. It does depend a little bit on the hypothetical. Probably not.
The lady from Hennepin, Representative Hillstrom.
Thank you, Mr. Speaker. And so, members, I just want to make that real clear. That's the way I read the language as well, based on the common interest ownership provisions, that if you put in statute that it requires a 50% vote of all of the owners, this statute would preclude contractors, the person who builds it and sells it, and the person who buys it from contracting for the rules to be differently, thereby giving up your personal property rights.
Discussion to the bill. The clerk will take the roll. The clerk will close the roll. There being 108 ayes and 23 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day is House File 859. The clerk will report the bill. House File number 859, number 1 on the calendar for the day, an act relating to transportation, the first engrossment. The gentleman from Brown, Chairman Torkelson.
Thank you, Mr. Chair. Thank you, members. House File 859 is a Transportation Department bill. It deals with a variety of issues, but none of them earth-shaking. Contains MnDOT policy provisions changing some highway routes, changing conveyance some property that is currently under MnDOT control to the Historical Society, and changing slightly the way that the Minnesota Department of Transportation sells property. With that, Mr. Speaker, I would appreciate a green vote and would stand for any questions. I believe there are no amendments.
There are no amendments. The desk clerk will give the bill's third reading. Third reading, House File number 859. Third reading, House File 859. Discussion to the bill. The clerk will take the roll. The clerk will close the roll. There being 131 ayes and 0 nays, the bill is passed and its title agreed to. The next bill on the calendar for the day
is House File 985. The clerk will report the bill.
House File number 985, number 2 on the calendar for the day, an act relating to civil actions.
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker and members. House File 985 is a trespasser liability reform bill. This is a bill that came to me after having a conversation with some people about some property that I actually own and some of the concerns that I had about liability. And out of that conversation, this bill has come to be. What we're doing with House File 985 is trying to protect private property owners from some frivolous lawsuits. And this goes back to, in 2012, the American Law Institute passed their third restatement of torts. And in that third restatement of torts, which they hadn't passed in the past, in the first two, the restatement was seeking to upend a long-standing approach to recommending that courts impose a new duty on landowners to exercise care for all entrants on their land, including trespassers. And this restatement would, in my opinion, dramatically expand the rights of trespassers to sue landowners and impose potentially costly burdens on property owners and potentially leading to higher insurance premiums. In my opinion, this new rule could be particularly harsh on ranchers and farmers and residential property owners. Currently, there are 26 states, and you have some handouts that have been circulated, hopefully. There are 26 states that have passed very similar language to what we have on the floor today. They have passed with very large bipartisan support, many of them being a number to 0, 97 to 0, 29 to 0, 143 to 0. What this legislation would do is it would basically freeze, it would currently freeze the current law to preempt the courts from imposing or adopting the third restatement of torts approach. This legislation is not a tort reform bill, but it's a bill that seeks to abolish or restrict existing causes for action for trespassers, or doesn't do that, but rather just keeps in place current state law or our common law. So decisions that have already been made in the courts with regards to trespassing and injury, those would remain the same, and we would not be changing that. We are just trying to protect the rights of landowners, property owners, as we move forward. You can see, folks, that there's a tremendous amount of support for this bill in some of the handouts that you have on your desk. And with that, Mr. Speaker, I would be happy to address amendments.
There is an amendment at the desk. The clerk will report the amendment.
Lesh moves to amend House File number 985 as follows. The amendment is coded A17-0381.
The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Members, this amendment makes clear that common law, as proposed by Representative Fabian's bill, is not frozen with respect to a minor. So one of the most troubling aspects of the bill was that it has broad application to children who are not always necessarily aware of dangers on the property. And of course, this is where we get some of our scariest cases, where kids are injured and an ongoing danger is allowed to continue to be present despite the knowledge of that danger. So, and cases involving these children are usually very fact-specific, so freezing the common law is a dangerous proposition for our kids. Now, the current law, according to testimony in committee, is that 4-year-olds are expected to understand the obvious risks, and unless the Supreme Court overturns that before July 31st, that will become the law of the land in Minnesota without any ability to have the court review it if Representative Fabian's bill isn't passed. Now, I'd never presume to say what Representative Fabian intends to do with this bill, but I could almost guarantee you that you don't intend to do that. So I would ask for a yes vote on the amendment. And, Mr. Speaker, I'd ask for a roll call.
Roll call having been requested. Are there 15 hands? Seeing 15 hands, there will be a roll call. Discussion to the Lesh amendment. The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. Members, I would view this as a friendly amendment and encourage a green vote. Thank you.
The gentleman from Ramsey.
Mr. Speaker, I'd withdraw my request for a roll call.
The roll call has been withdrawn. Discussion to the Lesh amendment. All in favor say aye. Aye. Opposed say nay. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Lesh moves to amend House File Number 985 as amended. The amendment is coded A17-0382.
The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Members, this amendment makes clear what a trespasser is. But I think I've got an amendment. There is an amendment to the amendment offered by Representative Fabian, so maybe we want to deal with that first, Mr. Speaker.
There is an amendment to the amendment. The clerk will report the amendment to the amendment.
Fabian moves to amend the Lesh amendment to House File Number 985 as amended, and the amendment to the amendment is coded A3.
To the amendment, the gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. And what the A3 amendment does is simply takes the definition of trespasser that is in common law and inserts that into the bill.
Discussion. The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Would Representative Fabian yield to a question?
The gentleman will yield. The gentleman from Ramsey.
Thank you, Mr. Speaker. Representative Fabian, where in common law is this definition found?
The gentleman from Roseau, Chairman Fabian.
Thank you. Mr. Speaker, Representative Lesh, it's common law. It's not written in statute.
The gentleman from Ramsey, Representative Lesh.
From court, and it would be, excuse me, Mr. Speaker.
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. Representative Lesh, it would be in the other court decisions that have been handed down.
The gentleman from Ramsey, Representative Lesh, you have the floor.
Thank you, Mr. Speaker. Would Representative Fabian yield to another question?
The gentleman will yield. The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Representative Fabian, yeah, I know that. That's why I'm asking which court decision or decisions this language can be found in.
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. Representative Lesh, I do not know the specifics on that. Thank you.
The gentleman from Ramsey, Representative Lesh.
Well, Mr. Speaker, Representative Fabian, you're proposing to freeze the common law as it is interpreted in Minnesota. Now, that means this language, I'm presuming, is in a court case found in Minnesota common law. Now, it might not be. You could cite a case from Indiana and say now this is permanent statutory law in the state of Minnesota, and that would be statutory law, and no court could overrule that something else was trespass. But I bet you, I'm guessing you found the answer by now if Representative Fabian would yield to a question, Mr. Speaker.
The gentleman will yield. The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Representative Fabian, do you have a court case for me?
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. Representative Lesh, Poplar versus Wright.
Okay.
The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Would Representative Fabian yield another question?
The gentleman will yield. The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. I hesitate to ask, but Representative Fabian, do you know the fact pattern of that case?
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. Representative Lesh, no, I don't.
The gentleman from Ramsey, Representative Lesh.
Well, Mr. Speaker, members, this is part of the problem. We're proposing to freeze the common law in this bill. That means no court in the future can ever interpret or reinterpret what constitutes trespass for the purposes of this bill. Now that's a pretty big deal because let's say, for example, you go back to 1974, the Minnesota courts liberalized what was construed and relevant to landowners' duties with respect to a trespasser. Liberalized them, right? You guys hate that word. Okay, that's what the court did. And then the American Law Institute incorporated that Supreme Court case into the restatement of torts. So what you're saying is that the Minnesota law that you all wouldn't like went into the restatement of torts. You're not going to take that in, but you are going to take the Minnesota law as it's stated. That would freeze bad case law for all of you. And that's what potentially could be the case with this amendment to the amendment as well. So, Mr. Speaker, would Representative Fabian yield another question?
He will yield. The gentleman from Ramsey.
Okay, thank you, Mr. Speaker. Representative Fabian, I read this language, and I'm wondering, on line 1.5, where you reference substance, what kind of substance are you talking about?
The gentleman from Roseau, Chairman Fabian.
1.5. Substance.
Thank you, Mr. Speaker. Representative Lesh, it's my understanding that, these things have been pointed out in court cases in the past. A substance obviously has broad range of definition, you might say, a whole host of things that could be a substance. I think common sense could determine some of that.
The gentleman from Ramsey, Representative Lesh.
Okay, thank you, Mr. Speaker. Would Representative Fabian yield another question?
He will yield. The gentleman from Ramsey.
Thank you, Mr. Speaker. Representative Fabian, I read the language, has unlawfully or wrongfully entered the land through their physical presence or through the physical presence of another tangible object or substance which interferes with the owner's right of exclusive possession. Let me just throw a fact pattern out for you. Kidnappers hogtie someone and throw them in the trunk and drive onto a farmer's land, your land. Is the hog-tied person in the trunk in violation of trespassing on your land?
The gentleman from Roseau, Representative Fabian.
Thank you, Mr. Speaker. Representative Lesh, no.
The gentleman from Ramsey, Representative Lesh.
Well, Mr. Speaker, that's exactly what your language says, Representative Fabian. That's exactly what you're freezing into common law. And in taking out my language as it's proposed, and inserting this, I'm not exactly sure what you're trying to do, but that is the effect that it has. Members, that's why common law is so important to not be frozen. It would be ridiculous for a judge to determine that that counts as trespass. A person who gets kidnapped, hogtied, thrown in the trunk, and driven onto someone's land is not in violation of trespass in that land, or that shouldn't be the case. And if you brought a court case on trespass, a judge would laugh and throw it out, because that's what we let judges do. But your bill, Representative Fabian, by freezing the common law, would result in absurd rulings from the court. So I guess, no other comments on the amendment to ask for a red vote on this. Maybe you can do a little more work on this, Representative Fabian, but I'd ask for a roll call. Do we have a roll call, Mr. Speaker?
No, roll call having been requested. Other 15 hands, seeing 15 hands. There will be a roll call. Representative Lesh.
Thank you, Mr. Speaker. I ask for a red vote.
The gentleman from Hennepin, Representative Smith.
Thank you, Mr. Speaker.
To the comment earlier about the fact pattern, I just wanted to comment that I do not think it's in the best interest of this body to discuss the fact pattern of a case when we're citing this type of law. While I'm not familiar with the particular fact pattern, and Chair Fabian said that he was not either, I'm reasonably certain the judge that presided over the case was, and I think that's an important point to note. Thank you.
The lady from Ramsey, Representative Becker Finn.
Thank you, Mr. Speaker. Would Representative Fabian yield for a question?
The gentleman will yield. The lady from Ramsey, Representative Becker Finn.
Thank you, Mr. Speaker. So, Representative Fabian, I'm wondering how this new definition, particularly the word tangible object or substance, how would this affect the ability of landowners, farmers, individuals to seek remedies regarding air and water pollution? I'm specifically thinking feedlots, pesticides, other similar situations. When would those particulates be considered tangible in this definition?
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. Representative Becker Finn, I guess I failed to understand your line of questioning. We're talking about the property owners and having protection from the lawsuits. In this case, you're talking about something else on their property interfering with themselves. I'm sorry, I don't understand.
The lady from Ramsey, Representative Becker Finn.
Thank you, Mr. Speaker. So I guess I'll try to explain this further. So let's say you've got a feedlot operation and you've got some kinds of liquids or other substances that go over the property line onto somebody else's property, which to me would be potentially unlawfully entering the land through a physical presence. But then the question is of a tangible object. So, or in the case of a pesticide, if a small particulate crosses the boundary into another property, is that particulate, which may be poison and you may not want on your organic farm, or it just isn't what you would want on your property, at what point would that be considered a tangible object, or was this even considered with this language?
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. And Representative Becker Finn, again, I'm talking about something coming onto a private property owner's land. In this case, what you're referring to being a crop hail adjuster, as I've been in the past, when there's overdrift from spraying on one field and it drifts onto another field, that person's liability insurance in that case, and I've seen some of these, that person who was making the application of the herbicide, their liability insurance covers them. That's why we have homeowners and farm and ranch coverage on our insurance policies.
The lady from Ramsey, Representative Becker Finn.
Thank you, Mr. Speaker. So to clarify, Representative Fabian, if you would yield for another question.
The gentleman will yield. The lady from Ramsey, Representative
to clarify,
Becker Finn.
then you're saying that, I guess, I'm wondering if maybe you can give me some background information, because the word tangible does not make it clear that particulate matter would be considered trespass in this case. And so I just have some concerns here. So are you saying that you believe that the particulate matter would be considered tangible under this language?
Gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. Well, Representative Becker Finn, that hypothetical situation, again, I think I addressed in my previous comments. If I am spraying my soybeans and it drifts onto your alfalfa field, I have insurance to cover that. If you file a claim against against me for that inadvertent thing. So what this bill is doing is it's protecting me, and I don't know how you would ever define somebody who's applying herbicides to their crops, how that would ever be construed as being trespassing. We're talking about the physical presence of somebody on someone else's property. Those are the trespassers.
The lady from Ramsey, Representative Becker Finn.
Thank you, Mr. Speaker. So the way that this language in this amendment to the amendment is written, it does say, or through the physical presence of another tangible object or substance. So the way that this is worded, it does not actually require the physical presence of the person. It could be a tangible object or a potentially particulate matter. And my point here is really just, my concern is that this amendment has not thoroughly been vetted, and there are likely some far-reaching consequences to this that maybe we were clearly not considered when this language was written. And my concern is that we're really changing the rights potentially of a lot of Minnesotans in a lot of situations by putting this into statute. So that would be my concern. I would really encourage folks to vote no on this one.
The gentleman from Scott, Representative Lunan.
Thank you, Mr. Speaker. While we were doing this debate, I went ahead and pulled up the DNR regulations concerning trespassing. And I'm a youth hunter safety instructor, and so we work with these all the time. And on page 7, it defines what the definition of trespassing is, but it also includes certain exceptions to that are not considered trespassing. And one of those exceptions are if a hunter is out hunting, and let me clarify that. In Minnesota, to legally hunt on your own, you have to be age 12 or older. That's it. If that youth and his or her friends are out hunting, the law here allows for an exception. They are allowed to enter into that private land, even if the land has every indication that you are not allowed on this property, if they are retrieving their hunting dog. And that would put them into the situation where it makes an exception to them. So the amendment to the amendment is important to clarify some of that, to make sure we have protections for these landowners. That being said, on a broader point, there's a real problem with people who want to enjoy the outdoors with getting access to land. And some of these risks landowners take by allowing someone to get on their land that they don't know, that they don't have a comfort level with. You're going to see a big drop-off in that. One of the things I've noticed in my courses that I'm teaching is an incredible increase in new citizens who the culture they came from were hunters. And they want to do that here. The problem they run into is, where can they hunt? And we want to make sure we keep a fairness in the process from a litigation standpoint.
Discussion. The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. And while the other members were talking, I looked up the case, Poplar v. Wright. And Wright is an electrical cooperative. And the case is about stray voltage, Representative Fabian. So it made me think of that. I think it was Representative Paul Anderson's bill on the nuisance bill earlier in the session. It's an interesting, I guess, twist in now you offering this as a definition for trespass, that you're now making electrical utilities trespassers on land under the definition in this case. Okay. I don't think I have anything more to say about the amendment, Mr. Speaker.
Discussion on the amendment to the amendment. The clerk will take the roll on the amendment to the amendment. Members, please vote. The clerk will close the roll. There being 75 ayes and 56 nays, the amendment to the amendment is adopted. To the amendment as amended. Further discussion. The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. I would withdraw my request for a roll call if I already made one. I don't know if I did.
The request for a roll call has been withdrawn. Discussion. All in favor say aye. Opposed say nay. The motion is adopted. The amendment as amended is adopted. Further discussion. There are no further amendments to the desk. Clerk will give the bill's third reading.
Third reading, House File Number 985, as amended.
Third reading as amended. Discussion to the bill as amended. The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Would Representative Fabian yield to a question?
The gentleman will yield. The gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Representative Fabian, you said in your open comments you were concerned of the big bad wolf, the third restatement of torts, and I'm guessing, I guess we can all guess, that by the use of the phrase restatement, that means it's been stated before. Can you tell me, were there any other statements or restatements that you would have found more acceptable or better for the folks that you're trying to protect in this bill?
The gentleman from Roseau, Representative Fabian.
Thank you, Mr. Speaker. Representative Lesh. Well, Representative Lesh, I made no mention to the big bad wolf, just to be clear. I did not use the term big bad wolf, okay? No, I did not find anything else in there, but I do know that in the first two restatements of torts, there was nothing in those restatements that was restating this to, in essence, take away the rights of property owners and to make it more difficult for them possibly because of liabilities.
Gentleman from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Would Representative Fabian yield to a question?
The gentleman will yield. Gentleman from Ramsey, Representative Lesh.
Thank you. Representative Fabian, can you tell me how persuasive the language written by the American Law Institute in the restatement of torts, how persuasive is that to a judge who is considering a trespass case in Minnesota? Where does it fall on the echelon of controlling authority, or persuasive authority, or irrelevant authority?
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker and Representative Lesh. Well, you've spent a lot more time in a courtroom than I have, thankfully. And I would assume that all these different situations that come before the court would be weighed, I'll say, individually. It depends upon what the situation is that comes before the judge.
The gentleman from Ramsey, Representative Lesh.
Well, thank you, Mr. Speaker. I can tell you, Representative Fabian, it's relatively low. I mean, controlling authority is United States Supreme Court precedent on matters of constitutional questions, U.S. Court of Appeals, federal district court when it comes down to a federal question, or federal jurisdiction when the state law provides the rule of question. That's the Erie Doctrine. Representative Pepin, I know Representative Pepin knows the Erie Doctrine really well. If the state law provides for the rule of decision, when it comes to state law, it is the Minnesota State Supreme Court, Minnesota Court of Appeals, and then any other kind of persuasive, other judges and other jurisdictions in the state that have said something. Down below that are things like law review articles, restatement of torts. It's really, I mean, you can include it in a citation and a brief, but it's anything but this oncoming shadow of danger that people are worried about with respect to that's going to change trespass law in the state. So would Representative Fabian yield to another question, Mr. Speaker?
He shall. The gentleman from Ramsey, Representative Lesh.
Thank you. Since the bill freezes common law and says it's only this one standard, for example, trespassing is what we just passed, can you tell me what all the current duties of an owner are in statute or common law? And I mean, I'm assuming maybe you do because you own land, so can you tell me ones that you're aware of?
The gentleman from Roseau, Representative Fabian.
Thank you, Mr. Speaker. Well, I don't know the, excuse me, the exact details of that, but I do know that that you have an obligation, if you know that there are, say for example, children crossing your land to get to a bus stop, okay, you are then required to make sure that if you know that they are using that, even though they are kids, they are trespassing, you still have a duty of care to make sure that there's not something there that's going to be potentially harmful to them. Who knows what it might be. It could be a big hole in the ground. It could be a tree that is in danger of falling, any number of things like that.
The gentleman from Ramsey, Representative Lesh.
Thank you, and Representative Fabian, that's right along the track of exactly what you should be able to do. And that includes latent conditions, right? So if there's a stream that's dry in the dry season, but then it's rushing and you know that it's coming and it's full at another time after heavy rain, that it's included in that. But my question, I got another question for you, if he would yield, Mr. Speaker.
He will yield, the gentleman from Ramsey.
Is there a case along those lines? Is there a scenario or example that you can give us that was the impetus for this bill? Is there something happened in Minnesota that this bill is trying to address?
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. And Representative Lesh, for me personally, I addressed that in my opening comments. I had had some questions with regards to a small piece of property that I own, and had some concerns about liability when we were looking at my insurance and renewing it and all that sort of stuff. And then, as it would happen, down here, some other people did talk to me about the possibility of doing some things to protect landowners from liability and to put more responsibility on trespassers. And that's the nexus of this bill for me.
The gentleman from Ramsey, Representative Lesh.
Well, thank you, Mr. Speaker. And I mean, the reason I was wondering is this is taken pretty much verbatim from the ALEC boot camp document that y'all get passed out over there. We don't get it over here, but it's in the ALEC boot camp book. So I just didn't know if, despite the fact that ALEC wants this bill passed in Minnesota, if there was a specific scenario, and what I'm hearing is that there's not a case, just for ALEC apparently. But Mr. Speaker, would Representative Fabian yield another question?
He shall. The gentleman from Ramsey.
Thank you. Representative Fabian, does the bill provide any new protections for landowners, or can any be created under the bill? And is the current law adequate to protect landowners? Is it good enough where it will never need to be changed again and be frozen in the current bill?
The gentleman from Roseau, Chairman Fabian.
Thank you, Mr. Speaker. And Representative Lesh, that's a hypothetical. We do these kinds of things here in the legislature frequently. We just got done with Representative Kresha's bill a little while ago. That arose out of a situation that came to the state, I'll say. And no, there's no absolutes in this stuff, and I wouldn't be surprised that at some point in the future maybe something different happens and something gets changed. That's just the nature of what we do.
The gentleman from Ramsey, Representative Lesh.
Well, thank you, Mr. Speaker. And Representative Fabian, that's exactly the point. The reason Representative Kresha had to bring his bill was because to remedy an injustice. And we do not want to freeze the law that guarantees an injustice occurs, whereby someone has to come up to the Capitol to remedy your injustice of the bill that you passed. And the hypotheticals that you talk about, that's really important. Yes, we have to struggle with hypotheticals right up here, because if you leave this to the common law and if you let judges determine what qualifies, and now apparently judges are going to see cases where power companies are getting sued by individuals for stray voltage provisions because it's made expressly a condition of your bill. So maybe that's one of the injustices you're talking about. We're going to have to come back and fix next year, that there will be a rash of lawsuits against utilities by adjacent landowners that you just made it easier to do. I don't know. But in most situations, if you let the common law handle that, a judge could specifically determine the parameters of that, as opposed to us saying, no, the common law is frozen and you can't do anything else. So, members, I think you can see just by some of the questions here of all the issues that are rife in this bill. I don't think it's well thought out. And I would just note, in closing, Mr. Speaker, that, and I think I mentioned this to you in committee, Representative Fabian, that this isn't the first time people thought it was a good idea to freeze common law. You know what? We've got enough scenarios. We got enough hypotheticals. They've all happened. There's going to be no such thing as a new one. And we've done that multiple times before in other societies. In fact, I told you in committee it was Justinian in the 6th century who came up with the codification. It was called the Justinian Code. And it had the Codex, which is the equivalent of our statutes, Minnesota laws. And then it had the Digest, which was a list of judges, essentially judges' decisions about different fact patterns that were based off of those laws. And he said, when he codified it, Justinian, this was in the middle of the 6th century, he said, okay, we've heard all the new stuff, it's done, the Digest is done, there can be no new decisions made off of this. And Justinian had to relatively quickly backpedal off of that to say, yeah, by the way, we were wrong, there are new scenarios that we're going to have to deal with. I would hope that with the example of history showing us that that's a bad idea, and some of the examples provided on the floor here today, that we'd think better on this, send this bill back to get a little bit more work done, and I'd ask for a no vote.
The gentleman from Hennepin, Representative Hertaus.
Well, thank you, Mr. Speaker. Would Representative Lesh yield for a clarification question?
The gentleman will yield. The gentleman from Hennepin, Representative Hertaus.
Thank you, Mr. Speaker. Representative Lesh, there's been an interesting debate. I listened to you make the claim that in this circumstances you're describing that the court would rule with an absurd ruling. And it's been my experience in litigation that the doctrine of absurdity really requires the court to rule the common sense meaning rather than the literal meaning. Is that what you meant by that, or were you suggesting that the courts would actually rule an absurd ruling under the absurdity doctrine?
Member from Ramsey, Representative Lesh.
Thank you, Mr. Speaker and Representative Hertaus. Judges have to follow the law as set by statutes. If that result of that ruling would result in an absurd result, then judges go to look to different questions about legislative intent. And you are entitled as a judge to examine legislative intent, but that's way down on the priority of things that judges look at as well, too. So if it's clear that we intended the language to be this way based on the discussion, and based on the discussion we've had here and today in committee, that's exactly what we intend. That's the ruling that judges would render, and we get this all the time. And in fact, people remember the Timber J bill, right, where we said specifically tax information about taxpayer dollars and about what is done by local units of government should be public. You should be able to see that. And despite the fact that that's clearly what we intended, the Supreme Court in 2013 said, well, it wasn't written expressly into the contract, so no, all that information is screened. And that was an absurd result, which we had to come back here and pass the Timber J bill to reverse that. And they specifically said in their ruling, listen, the legislature is going to have to address this. So, yes, I mean, there is some wiggle room with respect to absurdity when the statute does not express specific direction.
Representative Hertaus.
Thank you, Mr. Speaker. Well, I appreciate that because I wanted to clarify that, because it seemed to suggest in your debate that no matter what the statute is, it would result in an absurd ruling. And I think what I heard you say was somewhat in agreement with me, that under the doctrine of absurdity, excuse me, I still have Kermit the Frog in my throat. He's been there for 2 days now. But anyway, that in our American courts, generally, there's a responsibility to not make an absurd ruling and to rule in the common sense interpretation in light of the literal meaning. Thank you.
Member from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Members, a couple of points of clarification. The good people at the American Law Institute They put a lot of work into these restatements of torts, a lot of work. And they are, in fact, recommendations. They are judges and attorneys from throughout the country, and they are simply recommendations. This body, in this House of Representatives, we get to decide public policy and how these laws are going to be defined. In this case, we're choosing to deviate from the third restatement of torts. And in this particular case, and it is a good idea to do so. I refer all members to this map. Iowa last week voted, all but one member of their legislature voted to approve this exact same language, 99% of the same language. Look at the map. Members, everybody around us has this law on their books. This is a common sense idea. The narrative today is that this is some sort of obscure, crazy idea. This is a common sense idea that's going to help out everyone throughout the entire state of Minnesota. I strongly urge a yes vote on this bill.
Further discussion to the bill. Seeing none, clerk will take the roll on the bill. You got 3 left. Clerk will close the roll. There being 85 ayes and 46 nays, House File 985 as amended is passed and its title agreed to. Calendar for the day. Next bill on the calendar for the day is House File 1226. Clerk will report the bill.
House File number 1226, number 4 on the calendar for the day, an act relating to taxation, making policy, technical, and clarifying changes. The first engrossment.
Call upon the member from Fillmore, Representative Davids, to introduce his bill.
Thank you, Mr. Speaker and members. House File 1226 is the department's policy and technical bill. It was first heard in committee in 2015. It was included in the 2016 tax bill. And now we would I'd appreciate your support. This is for the department, their policy and technical bill.
There is an amendment at the desk. The clerk will report the amendment.
Sundin moves to amend House File number 1226, the first engrossment as follows. And the amendment is coded A1.
Call upon the member from Carleton, Representative Sundin, to introduce his amendment.
Thank you, Mr. Speaker. Statewide, there exists a problem as far as reimbursement to our providers of emergency medical services. And the Cloquet Area Fire District was formed a number of years ago to address this problem and provide better services throughout our area. And the amendment, the bill was actually heard in committee and moved through without opposition, but I realize now there's some angst from the other side of the aisle, and I'm hoping to work on this before May 22nd and get some results. Today is not the day, so I'm going to withdraw the amendment.
Representative Sundin withdraws the A1 amendment. Further discussion to the bill.
No further amendments at the desk.
There are no further amendments at the desk.
Clerk
will give the bill its third reading.
Third reading, House File number 1226.
Third reading. Discussion to the bill. Seeing none,
Clerk will take the roll on the bill. Clerk will close the roll.
Oh, thank you so much.
There being 130 ayes and 0 nays, the bill is passed and its title agreed to. Next bill on the calendar for the day is House File 1118. Clerk will report the bill.
House File number 1118, number 3 on the calendar for the day, an act relating to real property, the first engrossment.
Call upon the member from Wright, Representative Lucero, to explain his bill.
Thank you, Mr. Speaker. So, in Minnesota, in regards to real estate transactions, the buying and selling of property, when a buyer makes an offer to a seller, there are typically several contingencies. One of them might be contingent upon the successfully obtaining financing, contingent upon an inspection, contingent upon appraisal, things like that. And then if the buyer is unable to move forward with the transaction, they're able to cancel the purchase agreement. And that notification of cancellation can currently occur electronically. But when the transaction is in regards to a CIC property, which is common interest community, more commonly known as townhomes or condos, with a homeowners association, there's a required disclosure that the seller needs to disclose to the buyer, and that is the HOA documents. And the HOA documents contain details such as the articles of incorporation, the bylaws, the homeowner dues, the financials of the HOA, minutes for the past year or two of the HOA, etc. And when those are disclosed, there is a 10-day window. And if upon review of those documents, after the seller discloses them to the buyer, if the buyer, for whatever reason, doesn't want to move forward with the transaction, current law does not allow, thank you, Mr. Speaker, current law does not allow the cancellation, the notification of cancellation due to the disclosure of those HOA documents to be electronically. It has to occur in writing. So this simply modifies that so that the notification of cancellation can occur electronically as other cancellations can currently occur. And with that, Mr. Speaker, I'll stand if there are any questions.
There are no amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File number 1118.
Third reading. Discussion to the bill. Discussion? Seeing none, the clerk will take the roll on the bill. Clerk will close the roll. There being 131 ayes and 0 nays, the bill is passed and its title agreed to. Next bill on the calendar for the day is House File 1542. Clerk will report the bill.
House File number 1542, number 6 on the calendar for the day, an act relating to human rights, the first engrossment.
Call upon the member from Hennepin, Representative Smith, to introduce your bill.
Thank you, Mr. Speaker. Members, House File 1542 is a continuation of the discussion that we've had over the last couple of years about making the American Disabilities Act not a vehicle for a handful of attorneys to make money in a very unethical way. This bill has some revisions from last year's version. We suspected last year the compromise needed at the time was going to continue with the lawsuits. The lawsuits have continued. We have scores and scores of documented cases and even hundreds and hundreds of cases that did not make a reporting mechanism, that did not make it to court. I want to thank my co-author, Representative Fisher, for his work on this bill, as well as all of our partners, some of which are legal aid, as well as the State Council of Disability, that I received a letter of support for this bill. The Minnesota Department of Human Rights is neutral on this bill. This bill continues to be something that we work on. I ask for your support with this bill. Thank you.
There is an amendment at the desk. The clerk will report the amendment.
Smith moves to amend House File number 1542, the first engrossment, as follows, and the amendment is coded DE5.
I call upon the author of the amendment to explain his amendment.
Thank you, Mr. Speaker. Members, this amendment is the collection of work from all of the partners at the table to have the system set up where we can increase access to these businesses for people that are disabled. That is the goal of this bill and stopping these abusive lawsuits. This bill reflects the best way to do that we know today. I ask for your support. Thank you.
Discussion to the amendment. There's an amendment to the amendment. Clerk will report the amendment to the amendment.
Pinto moves to amend the Smith amendment to House File number 1542 as follows, and the amendment to the amendment is coded A17-0389.
Call upon the author of the amendment to the amendment, Representative Pinto.
Thank you, Mr. Speaker. So, members, as Representative Smith said, this bill is part of this process of dealing with a situation where, as Representative Smith said, a handful of attorneys have been making money off of claims related to access by folks with disabilities to place of public accommodation. The delete all amendment, well, let me back up for a second. So I think it's important for members and the public to realize that we, of course, have a process where people can assert claims for violation of their rights. Those include claims for violations of their human rights. There are a number of those possible claims that may be made that are contained in Section 363A, Chapter 363A, pardon me. What we've done in this past term and in this bill as well is we have we've imposed a little bit of a notice period, a little bit of a delay, recognizing that there has been, as Representative Smith said, some concern with how these attorneys are working things. The amendment, the secondary amendment that I'm proposing, deletes a provision in the bill which requires an additional delay. So basically, the bill has a 60-day waiting period before a claim may be made. It also imposes an additional 30-day waiting period when a business makes a claim that there is the weather is preventing a change to be made. What the secondary amendment does is it removes that additional language. Members, The 60-day notice period is merely a period of notice. It is not a period during which, it's not a cure period. Even if the business makes the change requested, still the suit may go forward. This is an underlying component of the bill. The reason for that, of course, is that there does need to be an incentive for folks who are disabled to be able to actually pursue their rights. And so this is not a cure period, it's merely a notice period. There's no reason that there be an additional 30 days when the business simply cites weather as a reason. It should be able to be that the suit can proceed if that's what the person decides to do. And so members, I would ask for your support of the provision to simply remove these lines relating to that additional 30-day delay during which people who have disabilities may be asserting their rights.
Discussion to the amendment to the amendment. Representative Smith.
Thank you, Mr. Speaker. Members, if we lived in Florida, this amendment would probably be okay. But we can't control Mother Nature in our great state. I ask for a no vote on this. Thank you.
Representative Pinto.
Thank you, Mr. Speaker. Well, what I would say to Representative Smith and to the members is, here's the thing. These claims are based only when a change may be made that is, quote, readily achievable. You only get that claim if it's readily achievable. If there's some change the business is going to make to address the concern that's expressed and it is not readily achievable because it's the middle of winter, because there's something happening with weather, well, then no claim can be made in the first place. If we were in Florida, presumably the complaint, the point would be made, well, you know what, it's too hot to make this change. And maybe that in summer in Minnesota, the business may say, you know, it's so sunny, we've got workers who are off of their cabin. Who knows what comment may be made based on weather. The way the bill is set up right now, the way the delete all amendment is that the business simply says we need an extra 30 days for weather. There's no sort of oversight over that. It really turns it into a 90-day delay in which this person who has disabilities is being delayed from their ability to assert their rights. So members, I would urge you to support this. Remember, this is all a big exception to the general process that we have to allow people to assert their rights. If we're going to make that kind of exception, let's make sure that it's a focused exception. There's no need to add this additional delay for people who have disabilities. Whether we're in Florida or whether you're in Minnesota, people who are experiencing disabilities should have their rights protected.
Representative Smith.
Thank you, Mr. Speaker. Members, I appreciate Representative Pinto's discussion about this bill. He has been a part of this discussion for over the last year and a half, and his contributions are noteworthy. I ask for a no vote on this amendment. Thank you.
Further discussion to the amendment to the amendment. Seeing none, all those in favor of the amendment to the amendment signify by saying aye. Aye. All opposed, no. No. The amendment is not adopted. There is another amendment to the amendment at the desk. The clerk will report the amendment to the amendment.
Pinto moves to amend the Smith Amendment to House File Number 1542 as follows, and the amendment to the amendment is coded A17-0390.
Call upon the author of the amendment to the amendment, member from Ramsey, Representative Pinto.
Thank you, Mr. Speaker. So members, this amendment is seeking to address another concern with the delete all, with what will become the bill. As you heard Representative Smith say at the very beginning, the concern here is a handful of attorneys who are making money off of this. There was one attorney in particular finding clients. I'm happy to say that he has since been disbarred. I understand the concern, though, that he's shown the way for others. So a handful of attorneys making money off of this. That's fine, but what this bill does is it also applies to people who are representing themselves, to pro se litigants, to people who have disabilities, and who are attempting to assert their rights on their own. That has nothing to do with attorneys making money off of this. Nothing to do with attorneys trolling for clients. It should be that those pro se litigants should be carved out of this. And I appreciate the comments of Representative Smith, and I certainly thank him and Representative Fisher for their leadership on the bill and for moving this forward. Let's focus on the problem that this started, which is the attorneys making money and not people representing themselves. Let's not impose an additional burden on people. Let's allow people who have disabilities to be able to assert their rights. Thank you, Mr. Speaker.
The member from Hennepin, Representative Smith.
Thank you, Mr. Speaker. Members, the basis of this bill is to increase accessibility for people that are disabled and to stop these abusive lawsuits. I do not think it is too much to ask for 60 days, or if you need a little bit additional time because of the weather, to hold on the forward progress of the lawsuit based on the fact that if you have representation or not. An additional concern with this is one of the handful of attorneys that are going around abusing this area of the law on the backs of people who are disabled is himself disabled. So if you're an attorney and you're disabled, we're carving out an exception for you. We will be back here in this body 1 year from today with an exception for that particular area of the law if this becomes law. I ask for a no vote. Thank you.
Member from Ramsey, Representative Pinto.
Thank you, Mr. Speaker. And Mr. Speaker, members, I guess I would flip that around and say, let's not create law where someone who has disabilities happens to be an attorney. Let's allow people who have disabilities to assert their rights. And if they happen to be attorneys, to my mind, that shouldn't affect things. The problem has been people who've been finding clients and making money off of this. This would apply to that. I would urge you to support this amendment. Let's focus on the problem that started all this in the first place. Thank you.
Further discussion? Seeing none, all those in favor of adoption of the A17-0390 amendment to the amendment signify by saying aye. Aye. All opposed, no. No. Motion amendment is not adopted. Members, we are now on the Smith amendment to the bill, House File 1542. Member from Ramsey, Representative Pinto.
Thank you, Mr. Speaker. So members, you're aware of a couple of concerns that I brought about the bill. I guess I just want to just note again that we have a process for asserting rights. We should be real careful when we make exceptions to that process. Again, I'm grateful to the bill's author and co-authors, others, because it's clear that an exception has been needed in this area. My concern, though, is we want to be really careful about tailoring that exception. If we're going to have an exception for people who have disabilities and who are making claims, we want to make sure to be very careful about that. I guess it concerns me the bill's author said that the Human Rights Department is neutral on this bill. It does seem to me that if we're going to be going into an area of human rights and going to be limiting people's ability to assert their rights, we want to make sure that we're very careful about that. I guess I would love to have the Human Rights Department's active support for this bill, and I want to make sure that we're protecting the rights of people who have disabilities. So I'm going to urge folks to not support this bill at this time. I appreciate the process that's moving forward, and I'm hopeful that we can continue to do that. But I feel like this is hitting a much bigger target than where we've been aiming at. Thank you. Oh, and I ask for a roll call on the amendment, Mr. Speaker.
Roll call being requested. Seeing 15 hands, there will be a roll call. Discussion to the amendment. Representative Fisher.
Thank you, Mr. Speaker. I rise in favor of this amendment that Representative Smith has put forward. I think this represents a lot of great work that has happened over the last couple of years. This has been a very complex issue. It is one that we did some work last year. We knew it wasn't going to be finished. We also know there's still a lot of work left to be done. We know that this is not going to fix all the problems out there, but this is a good movement forward in the progress to help start protecting some of our smaller businesses. I know that Representative Smith and myself are committed to continue to work with all the different groups that are out there. We've got other bills that we've introduced recently to start bringing together work groups to take a look at some of the bigger problems that exist in this area, because it is rather complex. And I think that it is important that we keep on moving, support the current bill that is out there in the current form so that we can continue the discussion. We've made a lot of progress. I appreciate the work that Representative Smith has done in changing the focus of where we are to where we are today. And I know that we will continue to work with the groups out there, moving this forward not only this year, but when we come back again next year, because there's more work that we still have to accomplish. So I would ask for a green vote on this.
Member from Ramsey, Representative Pinto.
Mr. Speaker, members, I need to apologize. I jumped the gun. I'm urging a yes vote on the amendment. I really appreciate how this has moved forward. It certainly is an improvement over the underlying bill. I do have concerns with the underlying bill, but as far as the amendment is concerned, it certainly represents an advancement. I know a big effort at compromise moving forward. So I urge folks to support the amendment, but I do have concerns with the underlying bill. Thank you.
Further discussion to the amendment. Roll call being requested. Clerk will take the roll on the amendment.
Mr. Speaker, point of parliamentary inquiry.
Recognize the member from Morrison, Representative Kresha. For what purpose do you rise?
Was there a roll call requested on that amendment?
Yes, there was,
Okay.
Representative Kresha.
Thank you, Mr. Speaker.
Clerk will close the roll. Dean M. votes aye. Being 128 ayes and 0 nays, the amendment is, motion prevails and the amendment is adopted.
No further amendments at the desk.
There are no further amendments at the desk. The clerk will give the bill its third reading.
Third reading, House File Number 1542, as amended.
Third reading. Discussion to the bill.
Mr. Speaker.
Representative Pinto.
Thank you, Mr. Speaker. I've certainly said plenty. I would simply urge a no vote on the bill, but appreciate the efforts being made and hope that we can continue to address this concern. Thank you, Mr. Speaker.
Member from Blue Earth, Representative Considine.
Thank you, Mr. Speaker. Representative Smith, are you familiar with the phrase, even a blind hog gets an acorn now and then? No. Well, you don't need to answer that. Nice bill is what I'm trying to say. There's been some 70 of these filed in Mankato. They are primarily against small local businesses that do not have the resources to fight them. They almost completely leave the big box stores and the franchises alone. So I will be supporting this bill. I'm sure there may be some tweaks later on, but right now, at least in my neck of the woods, this is needed. Thank you.
Further discussion to the bill. Member from Scott, Representative Vogel.
Thank you, Mr. Speaker. I will also be supporting this bill. In our small business that I'm part of, we actually had this happen to us. And I can tell you that it wasn't intended, I don't think, in any way to clear up a difficulty, because when we refused to participate, it went away. So basically, it was, as I would look at it, a thievery of trying to get money out of us. It did eventually cost us some legal fees to say we weren't going to do it. But certainly, and the other part of that is in our business, we deal with a lot of small businesses. And a lot of times these demands are $5,000 to $10,000. The repairs may not even exceed that. These small businesses, especially on Main Street, are already struggling. So to put an additional burden of attorney's fees in front of people when they could use those resources if they knew about it to fix the problem is certainly a better use, I think, of the funds than going into lawsuits. So I would urge support as well, because I really think that this is a friendly bill for especially small businesses that are maybe already struggling.
Member from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. When I first heard about this situation going on, I was outraged. I think one of the first cases I heard about was the bulldog over in Minneapolis. Someone was trying to extort them, and that's absolutely what it looks like, is extortion. Someone comes in, does a drive-by, sends you a letter, you got to pay up. No risk on the one side and all the risk on the other side, and it's incredibly frustrating, and I get that. But when we try to pass bills that are there to address certain specific behavior by certain individuals, it gets really tricky and really tough. And sometimes, oftentimes I should say, we way overcompensate and overextend. And this bill, while well-intentioned to address the situation, of lawyers filing these drive-by lawsuits with no intention of remedying the situation covered by law. We cover and restrict the rights of the community of folks who have a disability and are just trying to get in. We impact them. And why would we pass a bill that seeks to address their rights to access that impairs their rights to get access to these same establishments? This has the effect, because we're frustrated about these specific lawyers, it's like trying to kill a mosquito with a sledgehammer. We could do this in a surgical way, or we could work on it more, but the Smith DE amendment allows for a mandatory 60-day notice for filing an accessibility claim by our disability community who have been fighting for safe and adequate access for over 26 years. We do not impose these requirements on anyone other than the disabled. Now, the bill seeks to address bad behavior by certain professionals. And in doing so, we decide we're going to set up more barriers for folks who have a disability. That just does not seem right to me. In addition to the new mandatory notice provisions, the amendment places new requirements on those who want to represent themselves with legal claims. Again, this is a requirement that we only place on folks trying to get access to locations if they have a disability. And in addition to the mandatory 60-day period, this amendment provides another 30 days if the business wants to claim some type of weather condition prevents them from correcting a violation, when there is no obligation to even try to correct a violation during the initial 60 days. So the actions of a few have tarnished the rights of many. And not just the many, but the many who I would like to think we would be more interested in preserving their rights rather than restricting their rights. We should react carefully to address concerns, but not prevent a community that needs our protection from asserting their legal rights. And unfortunately, that's exactly what we're doing in this bill. Proponents may say, well, it's the only way we can do it. I refuse to believe that. I think there is a way to address the bad behavior of a few without impacting folks in our community who have disability, who simply want to have access. But that's exactly what this bill does. That's why it's the wrong approach, and I'm a no vote.
Member from Ramsey, Representative Fisher.
Thank you, Mr. Speaker. Once again, I'd like to get up and encourage a green vote. We've made some progress over the last few years. I know there's issues that have remained out there. I know that it's been a very difficult avenue as we're trying to find the right pathway through here to make sure that where there is improper behavior going, that is dealt with, and also making sure we're protecting people's rights. I think the approach that we're getting at here is doing that job. I think that what we're seeing, normally we're seeing a response to an abusive pattern that has become quite proliferant. And that is why we're looking at it in a little different light and why there's an exception that needs to be looked at here. Because in many of the instances that have been happening in my community, there have been instances where things are off by 1/4 of an inch or 2 inches. And so the businesses in those instances have gone to court and they spent $10,000, $15,000, or $20,000 to find out that yes, the instance was a very minor and it was not really a violation of the law. These are the things that we're dealing with out there, and it's becoming quite common. And as a result, we have to be thoughtful, and I think the process we've been using is doing that. We did a little bit of work last year. We're doing some work this year. We're going to be coming back and doing more work on this again next year, because we want to be real respectful to make sure that we're protecting people who've got disabilities and at the same time protecting businesses who are being preyed on by unscrupulous people. Thank you. Please vote green.
The member from Nicollet, Representative Johnson C.
Thank you, Mr. Speaker. And members, I consider this bill a good example of an effective compromise that a lot of people have worked on. My compliments to those who have accomplished it. It addresses a very serious problem for small businesses in my community, and I encourage a yes vote.
Further discussion? Representative Smith.
Thank you, Mr. Speaker and members. I appreciate the discussion about this bill today and everyone's support. I especially want to thank the Minnesota Chamber of Commerce and all the chambers throughout the state that have come forward and collected the scores of cases of the egregious behavior of these attorneys that are forcing this bill to come forward. Representative Lesh spoke about how we need to protect certain groups at times, and I think this bill does that. I think a no vote is a vote with the handful of attorneys that are doing this egregious behavior and turning your backs on the people that are disabled. This bill will increase access for people that are disabled. This is a good bill. I want to thank the Legal Aid organization as well as the Minnesota State Council of Disability again for their support, and also the Department of Human Rights. They are a neutral on this bill, and I understand Representative Pinto's comments that he wishes they were a supportive of this bill. And I wish they were too, and we're working towards that. While they're not supportive, they don't oppose this bill. They are neutral. There is a distinct difference. They do not oppose, they are neutral. The Council of Disabilities supports this bill. Thank you. I ask for a green vote.
Clerk will take the roll on the bill. Clerk will close the roll. There being 110 ayes and 22 nays, the bill is passed as amended and its title agreed to. Without objection, we will revert to messages from the Senate.
Message from the Senate. This is the Theis motion. Mr. Speaker, I hereby announce the passage by the Senate of the following House file, herewith returned as amended by the Senate, in which amendments the concurrence of the House is respectfully requested. House file number 792, an act relating to construction codes, and the message is signed Cal R. Ludeman, Secretary of the Senate. Theis moves that the House concur in the Senate amendments to House file number 792 and that the bill be repassed as amended by the Senate.
Call upon the member from Stearns, Representative Theis.
Thank you, Mr. Speaker. The amendment that was added in the Senate actually is a technical amendment to make sure that the effective date of the expedite rule is upon the date of publication in the State Register. So the Senate amendment waives Minnesota Statute 326B.13, and that's the law that requires new construction codes to be effective 270 days after publication in the State Register. What this does is just actually put what we want to happen sooner rather than later, especially hitting the construction season this summer.
Any further discussion on the motion? Hearing no further discussion, all those in favor say aye. Aye. Opposed? Motion prevails. Clerk will give the bill its third reading.
Third reading, House File Number 792, as amended by the Senate.
Further discussion? If there's no further discussion, the clerk will take the roll on the bill. Clerk will close the roll. There being 132 ayes and 0 nays, the bill is repassed as amended by the Senate in its title agreed to.
Message from the Senate, and this is the Kresha motion. Mr. Speaker, I hereby announce the passage by the Senate of the following House file, herewith returned as amended by the Senate, in which the amendments and concurrence of the House is respectfully requested. House File Number 400, an act relating to state contracts. Kresha moves that that the House concur in the Senate amendments to House File Number 400, and that the bill be repassed as amended by the Senate.
I recognize the author, Representative Kresha, who will explain the Senate amendments.
Thank you, Mr. Speaker. Members, that is my motion that we concur and we pass the bill as amended.
Discussion to the Senate amendments. There being no further discussion, all those in favor of the motion to concur with the Senate amendments say aye. Those opposed, nay. Motion prevails. Clerk will give the bill its third reading as amended by the Senate.
Third reading, House File Number 400, as amended by the Senate.
Third reading. Further discussion? There being no further discussion, the clerk will take the roll on the bill. Clerk will close the roll. There being 103 ayes and 28 nays, the bill is repassed as amended by the Senate and its title agreed to. Recognize Representative Baker.
Mr. Speaker, a point of personal privilege, Mr. Speaker.
State your personal privilege.
Thank you, Mr. Speaker and members. I wanted to make an announcement today that regarding tomorrow is the National Prescription Drug Take Back Day. And I was asking many folks in my district about it and the awareness of it, and I wanted to bring this to my colleagues here in this House floor to do me a huge favor to let your folks back in your communities know how important this day is. Tomorrow, April 29th, Saturday, from 10 a.m. to 2 p.m., nationally, folks are going to be standing by to let you drop off medications that you don't need any longer in your medicine cabinets. And we're asking folks around the state of Minnesota to please share this information with your updates, your newsletters, the way you communicate with your members of your community to let them know how important that is. Too many people are dying and getting addicted, and a lot of this, folks, starts from medicines that are sitting in a medicine cabinet that you have no idea of even what is in those cabinets. So please, let's clean them out. Let's talk about this with our neighborhoods. Tomorrow is National Prescription Drug Take Back Day, and I would appreciate your help in helping us fight addiction. Thank you, members.
Reports from the Committee on Rules and Legislative Administration.
Report from the Committee on Rules and Legislative Administration. Pepin from the Committee on Rules and Legislative Administration, pursuant to Rules 1.21 and 3.33, designates the following bills to be placed on the calendar for the day for Monday, May 1st, 2017, and establishes a pre-filing requirement for amendments offered to the following bills. House File numbers 947, 997, 1242, 1545, and 2174, and Senate File numbers 799, 844, 870, 1020, 1113, and 1135.
Motions and resolutions. There are copies of the non-controversial motions at the House desk and online. If there are no objections, we'll take action on these motions first. Hearing no objections, the motions prevail.
Lomer introduces House Resolution number 3, a House resolution recognizing the first Thursday in May as a day of statewide prayer, fasting, and repentance in Minnesota. The resolution is being referred to the Committee on Rules and Legislative Administration.
Announcements. Member from Dakota, Representative Hansen.
Thank you, Mr. Speaker and members. Tomorrow is Arbor Day in Minnesota, and as is our annual tradition, we have some trees for you. And so I first want to thank the pages who have spent all morning preparing trees for the members. A little bit on Arbor Day as we work in this annual bipartisan effort. Usually we talk about the American history, the U.S. history with Arbor Day, but doing a little more research, actually the first Arbor Day in the world was in 1594 in the Spanish village of Remedios. And to commemorate that, and I'll try to do this correctly here, the place is named Almeida de los Remedios, still the location where the trees that were planted then are, and planted subsequently, still occur. Then in 1805, the first modern day Arbor Day also occurred in Spain, and it was a priest during the times of Napoleon who thought we needed, as people, to celebrate trees. And so we start, every state has a specific Arbor Day. In Minnesota, it's the last Friday of April, and we have a state tree. So I'm going to yield to Representative Lehman to talk about our state tree, which is being distributed today.
I recognize Representative Lehman.
Thank you, Mr. Speaker and members. Well, the red pine, which is also known in Minnesota as the Norway pine, was made Minnesota's official state tree in 1953. A little bit of the backstory. Through the efforts of the Fridays Study Club in Minneapolis and backed by the Minnesota Federation of Women's Club, legislation was sponsored by Senator Gordon Butler and Representative George French. It was signed into law by Governor C. Elmer Anderson on February 18, 1953. Language at that time noted the sturdiness and majesty of the tree and how it helped lay the foundation for the wealth of Minnesota. Red pines are tall, stately trees that reach the height of 60 to nearly 150 feet. Their trunks are straight and uniform, and they may grow to 5 feet in diameter. They're found in many parts of northern and northeastern Minnesota, and they're popular for forest planting because of their disease and insect resistance. Some of you may know that the tallest Norway pine in Minnesota stands in Itasca State Park. It's 300 years old, and it stands at 120 feet high. And with that, I would like to yield to Representative Julie Sandstedt.
Recognize Representative Sandstedt.
Thank you, Mr. Speaker. Members, I have the privilege of sharing instructions on how you get to plant your tree. It's important that the roots are kept moist and the hole is twice as wide as the root ball is, and it should be slightly deeper than the length of the root length. Thank you, Mr. Speaker. Be sure as you place the tree into the hole that the roots do not bend. Backfill the hole, compress the soil, and be sure to water. If you have any questions, directions are also in the DNR pamphlet, which we've received. And with that, I would like to yield to Representative Loon.
Thank you, members. I have the pleasure of telling you about where these trees come from. It is from a nursery here in Minnesota, Schumacher's Nursery and Berry Farms from Heron Lake, which I believe is actually Representative Hamilton's district. I did a little research on them. They are a family-owned nursery and farm that dates back to, I think, 1915 in the state of Minnesota. And so they are well known for their trees. They specialize in native seedlings, and they have over 100 varieties of them. They're really known as a conservation nursery. And the family started again back in 1915, and they had a livestock and other farming. They started planting strawberries before the Depression, and they now have a pick-your-own strawberry farm that is still in operation, and I think their website said that they've had strawberries for 100 years now at that site. So Dean and Judy Schumacher and their sons wives and families run the operation. They got just under 200 acres, and they are a wonderful family farm, and we're very pleased to enjoy the trees that comes from this wonderful nursery.
Announcements. Representative Gunther.
Thank you, Mr. Speaker. The Legacy Conference Committee will meet 1/2 hour after session adjourns in room 10.
Further announcements. Representative Fabian.
Thank you, Mr. Speaker. And just wanted to point out with regards to the trees that former member Denny McNamara was very instrumental in helping to get this day organized. Thank you.
Representative Knobloch.
Thank you, Mr. Speaker. Republican members of the Ways and Means Committee will meet immediately after session today in room 400 South, and we will be having a Ways and Means Committee at our regular time on Monday.
Representative Nornes.
Mr. Speaker, the Conference Committee on Higher Education will get back to session or reconvene in 15 minutes in room 123.
Further announcements. Representative Carlson L.
Members, the DFL members of Ways and Means will be meeting Monday morning, 9:30 a.m., just before the Ways and Means meeting.
Announcements. Member from Hennepin, Majority Leader Pepin.
Thank you, Mr. Speaker. I move that when the House adjourns today, it adjourns until 1 p.m. Monday, May 1st, 2017.
Representative Pepin moves that when the House does adjourn today, it adjourns until 1 p.m. Monday, May 1st, 2017. All those in favor signify by saying aye. All those opposed, no. Motion prevails. Representative Pepin.
I move that the House do now adjourn.
Representative Pepin moves that the House does now adjourn. All those in favor say aye. Aye. All opposed, no. The motion prevails and the House stands adjourned until 1 p.m. Monday, May 1st, 2017.